Hello, and welcome to an episode that talks about media trial. This is in continuation of the media trial episode 1, in which we discussed about the terminology, if the media trial is a fair trial, what are the restrictions by our constitution with respect to such trials, etc. I'm Swati Singh, a media professional for the last 10 years, specialized in mass communication. I have worked as a journalist with the Hindustan Times, Indian Express, Career Launchers, etc., and have also taught print and electronic media in various universities and colleges, including the Delhi University. Today, we shall be discussing the various restrictions that are imposed on the media by government bodies and law. We'll also discuss various cases and how these have a great impact on the audiences. Let's start by discussing the objectives of this episode. The objectives of this lesson include the stand-by Indian courts on media trial, impact of media trials are positive or problematic, and the norms to be followed by media to ensure a fair trial. So, let us start by addressing the influence of media trials that have on the society at large. Impact of the trial by media. Media has now reincarnated itself into a public court, which can also be referred as Janta Adalat, and has started interfering into the court's proceedings, so much so that it pronounces its own verdict even before the court does. It completely overlooks the vital gap between the accused and the convict, keeping at stake the golden principle of presumption of innocence until proven guilty and guilt beyond reasonable doubt. Nowadays, what we actually observe is a trial by media, where the media itself conducts a separate investigation, builds a public opinion against the accused even before the court takes cognizance of the case. By this way, it prejudices the public, as a result of which many a times it could happen that the accused, which should be assumed innocent, is presumed to be a criminal, leaving all his rights and liberty unredressed. When excessive publicity without a case and the suspect involved in the case by the media prejudice a fair trial or results in characterizing the accused as a person who has indeed committed the crime, it amounts to undue interference with the administration of the justice, calling for proceedings for contempt of court against the media. To an extent, it can be agreed that the media, by publicizing certain facts, as it was best seen in the Jessica Lal murder case, acts as a catalyst which is conducive to the speedy progress of the trial, and media activism of this nature is acceptable. However, once a trial has commenced, the media has no right to pronounce, based on its own perception, the innocence or guilt of the person involved in the case. Determination of the guilt or innocence of a person under our constitutional scheme is a function of the courts and not the media. Besides, irreparable harm can be caused to a person's reputation by prematurely judging him or her guilty. Also, let's talk about some of the landmark judgments. So, some of the landmark judgments with respect to such cases is when media has totally different group of people to handle high-profile cases in the criminal justice system. This may also influence the way the trial procedure, which includes the witness, evidence, and important elements. We have focused our research and analysis on the following cases, which show the influence of media on us and the criminal justice system. We start with P.C. Sen versus Unknown, 8 November 1968. In the case of P.C. Sen 1968, a special leave petition had been filed that in broadcast that had taken place on the night of the November 25, 1965 on All India radio station had been obstructive in the course of justice and had amounted to contempt of court as it gave out details of the accused. Justice Shah stated that any law related to the contempt of the court is well settled. Any act that's done or published to bring any judge of the court to the ambit of the contempt, or which tries to bring down the authority of the judge or the court, of that anything that tries to interfere with the proceedings of the law will be termed as contempt of court. Y.V. Hanumantha Rao versus K.R. Pattabhiram and A.N.R. 3rd September 1973. In the case of Y.V. Hanumantha Rao versus K.R. Pratibhiram and A.N.R. 1973, there was a curfew that had been imposed in a small district of Andhra Pradesh. It was brought before the court that the curfew that was imposed was arbitrary and there was no law upholding the same. During this time, while the case was pending, the Deccan Chronicle had published about the law of curfew and why it was imposed, along with a historical background, and stated everything about the case. It was observed that with the litigation was pending in the court of law, there shall be no comment made regarding that litigation, which may cause substantial danger or prejudice of any trial. For instance, the prejudice in the decision given by the judge, the witness, or any other general public having access to such media news. It was also stated in this case that even if a person who publishes such news believes in his or her capacity for it to be true, it shall still stand as contempt of the court for the reason that this truth was established before the verdict given by the judiciary. Sushil Sharma versus the State, Delhi Administration, 1st May 1996. In the case of Sushil Sharma, the State, Delhi Administration and ORS 1996, there was little evidence that the accused had murdered his partner. However, while the case was still pending in the court, the media started portraying the accused as a murderer and was capable of changing the views of the public even before the decision of the case. It held by the High Court of Delhi that the conviction of any person would solely be based on the facts of the case and not because the media wanted this person to be declared as guilty. The charges also have to be framed against the persons accused based on the evidence available on record and not based on what the media portrays the person to be. Secretary, Ministry of Information and Communication versus Cricket Association of Bengal, 9 February 1995. The court gave a wider meaning to the freedom of speech and expression, which emphasized that every citizen has the right to telecast and broadcast to the viewers any important event. Television and radio have also provided that the government has no monopoly over such electronic media, and such monopolistic power of the government was not mentioned anywhere in the Constitution or any other law prevailing in the country. This judgment thus brought about a great change in the prevailing broadcast media, and such sector became open to the citizens. The freedom of speech and expression includes the right to acquire information and disseminate it. Freedom of speech and expression is necessary for self-expression, which is an important means of free conscience and self-fulfillment. It enables people to control, to debate and social and moral issues. It is the best way to find out the truest model of anything sincere, which is only through it that widest possible range of ideas can circulate. It is the only vehicle of political discourse so essential to democracy. R.K. Anand versus Delhi High Court, 29th July 2009. The important questions relating to trial by media were examined by the Supreme Court. The case arose out of a sting operation carried out by private television channel NDTV to expose the unholy nexus between the prosecution, its witness and the defense in the infamous BMW hit and run case, resulting in the death of 6 people by a speeding BMW car which was driven by the scion of an influential and wealthy family. While the trial was pending, even after the 8 years of the incident, NDTV telecasted a sting operation to expose the manner in which a senior advocate appearing for the accused was negotiating with the help of special public prosecutor to sell out the favour of defence. The Delhi High Court then initiated the suo motu contempt proceedings and held the special public prosecutor and the defence counsel guilty of the contempt of court, and they were debarred from appearing in the Delhi High Court and its subordinate courts for 4 months. Then the appeal was filed before the Supreme Court. It was contended that NDTV was guilty of trial by media and it could have telecasted the sting only after obtaining the due permission from the High Court. The Supreme Court of India rejected the contention, holding that such a course would not be an exercise in journalism, but that case the media would be acting as some sort of a special vigilance agency for the court. The Supreme Court held that NDTV was not guilty of trial by media, and the phenomenon of trial of media was described as the impact of television and newspaper coverage on a person's reputation by creating widespread perception of the guilt regardless of any verdict in a court of law. The court dismissed the appeal of R. K. Anand and issued him a notice for the enhancement of punishment. The case of Sahara India Real Estate Corporation Limited versus Sebi, which is also known as the Media Guidelines case. The Supreme Court of India in 2012 constituted a constitution bench of 5 judges to consider whether the guidelines shall ought to be framed by the court in respect of the media reporting of the ongoing case or reporting of the cases which are pending before the court. In this case, there was an unauthorized leak of privilege communication by a private television channel, and the communication was related to the settlement proposals exchanged between the lawyers on the two sides. The Supreme Court of India passed an order saying that we are distressed to note that even without prejudice proposals sent by the learned counsel for the appellants to the learned counsel for Sebi has come on one of the television channels. Such reporting by television channel not only affect the business sentiments but also it interferes with the administration of justice. The court ordered both the counsels to make a written application to the court in form of interlocutory application, so that appropriate orders could be passed by the court with regard to the reporting of the sub judice matters pending before the court. The Sahara filed an application complaining the unauthorized broadcast by the television channel, and the Supreme Court of India opened a debate on media reporting of court cases on behalf of media houses and journalists. The mysterious leak to the media sparked the confidential exchange between the lawyers in the case, snowballed into the open-ended debate on media transgressions and the need to rein it with the guidelines. The Supreme Court of India, while recognizing media's right to report the court proceedings and recognizing the presumption of open justice, held that there may be certain exceptional cases where the reporting by media might adversely impact the administration of justice. In such cases, the reporting may be defended for a limited duration by the Supreme Court or the High Court. Such order of postponement must pass the test of necessity and proportionality. The case of Singh Rajput. Bombay High Court did not mince words while pointing out the fact that journalists today have lost their neutrality and the media has become polarized. The observations were made by the bench of Chief Justice Dipankar Datta and Justice Girish Kulkarni on Friday while hearing public interest litigations against the media trial in the Singh Rajput death case. The court was prompted to make the observations after the advocate of one of the respondent channels submitted a report authorized in 1947 by European Institute, which analyzed option between self-regulation and statutory regulation for the media, and concluded that there was no need for the government control, while clarifying that the channel was not guilty of the allegations made by the petitioners as it was not named by any of the petition's advocates. Ankit Lohia, appearing for Zee News, however, said that he wanted to make submissions in support of the contentions of other channels that there was no need for government interference in functioning of channels. He cited 1947 reporting of the European Institute and stated that the report had made it clear that the media should self-regulate instead of a statutory regulation. The Chief Justice made an observation on the submission of Lohia and said, "We are ruled by the rule of law." In India, there is a rule of law, right? How do you advocate that people who go around accusing others can find shelter or freedom of press? Journalists back then were responsible and neutral. Now the media is polarized. The case of Jasleen Kaur harassment controversy. Jasleen Kaur harassment controversy stemmed from the accusation of sexual harassment made by Jasleen Kaur against Jeet Singh in 2015 and the events that followed. In August 2015, Delhi woman Jasleen Kaur posted a photo of a man Sarabjit Singh on Facebook and accused him of harassment. The post immediately went viral on the Indian social media and garnered widespread attention. She received widespread support for raising her voice against the eve-teasing and sexual harassment on social media, including from national celebrities and politicians. Sarabjit was arrested the next day and was bailed the day after. It was followed by a trial of media in which Sarabjit was labelled by terms like national pervert and Delhi ka darinda, Delhi's predator, on national news channels. A few days after the incident, an eyewitness vouched for Sarabjit's innocence, which brought credibility to Sarabjit's account. After 4 years in 2019, the Indian court acquitted Sarabjit of all the charges and he was held innocent. On October 24, 2019, 4 years after the incident, the court passed the judgment. All the charges were dismissed and Sarabjit was held innocent. He was acquitted of all the charges against him. However, during the time, the man had lost his job and couldn't find any other source of income due to such media coverage. Therefore, the question arises that whether a media trial is positive or problematic. From the above such research and articles, it has been clear that the media trials have had more of a negative impact than a positive one. Media has to be properly regulated by the courts. While a media which has been controlled by the government is not good for democracy, the implication and result of unaccounted publications are even more damaging, not just to the reputation of the person, but also to the judgment imposed by the courts. Therefore, media trials have only served to help the people in only very few instances, but that does not happen in all the cases most of the time. Thus, it is necessary to have restrictions imposed on it. Media, as referred to by many as the eyes and ears of the general public and democracy, forms the backbone of our society. And as a responsible citizen, media is expected to take into consideration the reliance entrusted on it by the general public and confidence and faith entrusted on it, whereby common man blindly accepts the truth of the news published by media. This actually calls for the existence of a responsible media. No freedom, however sacred it may be, can be absolute. This is also true of press freedom. The press has an obligation, voluntary and self-imposed, that in presentation of truthful news and fair comments it adheres to the certain norms of decency and decorum, and that it does not indulge in vulgarity, obscenity, character assassination, violation of citizens' privacy, and incitement to offence, disorder and disintegration of the country. However, there is an urgent need to liberalize the sub judice rule, applying it only in important cases that will likely influence the trial and not to any act that might have the remote possibility of influencing it. Another main constraint on stings and trials by media is that public interest. If public interest is missing and either self or manipulative interest surfaces, the media loses its ground and invites the rage of the court. Let's talk about the norms that should be followed by the media for any media trial to avoid issues on the path of justice under the Constitution. While acting as a responsible media, it should follow certain norms in reporting of a crime or any news related to the same. We start with the accuracy of the case, which shall be maintained and verified before the same is reported or published and read of all. Every caution shall be undertaken to avoid any writing that is opinion-based, that is, either favouring or defaming any person or party. The right to privacy shall not be interfered with. Accuracy is of utmost importance while reporting court proceedings. Reports based on mere suspicion or personal opinion shall not be published. Appreciation of an act of violence shall be avoided always by the media. The heading shall not be purposely made sensational or provocative. It must be apt for the matter printed under it. Rectification shall be published without any delay in case of any particular error. Let's come to the conclusion. The various cases we talked about, the various important historical cases that mark the significant influence of the media trials, showed how media is so important to democracy. Media is truly trusted and does have a huge role in molding the public opinion because it is influential. Not only the freedom of press is subject to the laws of the land, such as the contempt and libel, but also is responsible to the society itself. It should accept certain responsibilities in the discharge of its function. And now it's time for a quick recap. Today we discussed the various cases and their impact on the society and the masses at large. Also, we questioned the media trials being fair, and we also talked about the Constitution's fair restrictions on freedom of speech and expression. Along with it, we discussed the reasonable restrictions on self-control media should follow while handling sensitive matters. And lastly, we talked about the various norms media should follow to hold fair trial. That is all we have for you today. Hope you enjoyed the session and learned about importance of media trials. We shall soon return with another interesting episode on media ethics. Until then, farewell and namaskar.